Good morning. It is Tuesday, August 10th. We're here for the regular board meeting with the county commissioners. We have all three commissioners in the boardroom with the administrator, the clerk of the board, and a company of guests. So with that, I'm calling the meeting to order, and please rise and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, with that, we will start with the updates. Keith.
Good morning, Mr. Chairman, Commissioners. Been another busy week. Unbelievable that we're in the middle of August already. In the past week, dealt with a couple things. I think everyone pretty well aware of the alarming uptick in COVID numbers in Franklin County. Spent some time with the health district and other decision makers in the community trying to see what can be done to increase the number of vaccines, encourage mask wearing and social distancing and some of those kinds of issues that we've been dealing with for a long time. But our numbers continue to outpace expectations in terms of hospitalizations and younger audiences being sick with this Delta variant. It's concerning. I met last week with representatives from throughout the state of Washington with the Attorney General's office, some discussion about the federal opioid settlement from litigation that's been ongoing for a few years now. They're getting closer to a settlement, and Franklin County is a plaintiff in that litigation with the remaining members of the class, which is cities and counties throughout the United States, that have filed litigation against the manufacturers of opioids that may have been over-marketed to the population and oversubscribed by doctors. And so that process is moving forward. Still, things remain to be seen how that's going to turn out for us. Now, with the auditor's office regarding the processing of certain insurance claims and how we're going to handle the accounting of that, we've got a proposal to create a new fund. There's a rounding situation we found in our One Solution program that makes it difficult to keep the auditor from having to spend a lot of time chasing just a few pennies that are related to rounding. So we think we've come up with a solution that's going to work, and we'll probably have a proposal in the 2022 budget process to accommodate for that. I'd like to throw out a couple of positive things to Sheriff Raymond and the law enforcement community. Last Tuesday night was their National Night Out event up in Basin City, well attended by a lot of people from Franklin County. Good opportunity for the folks to understand more about what is going on in law enforcement and showcase some of the special tools that they use for law enforcement purposes. And then also was able to participate in a ride along with a night crew of Franklin County Sheriff's Office Friday night. They're doing remarkable work to keep the county safe. I've been with county 6 years now, and I appreciate how big the county is geographically, but certainly impressed with the way those guys work together to cover all points of the county. We were on calls from up past Colotis to back here near Pasco, and those guys do a great job. So I want to commend the Sheriff's Office for the work that they do. All I have this morning. Thank you.
Commissioner Beck.
It just reminded me of when you first got here 6 years ago. We took a little flight around the perimeter of the county to accomplish a few things. One was to impress upon you how much of our county is ag land. And the other was, and this is sort of a personal point for me, how far it is from Pasco to that northeast corner of the county, and how long it takes deputies and how few deputies we have to cover that much terrain. So we've come full circle. That's great. This week, Greater Columbia Behavioral Health, pretty robust discussion about mental health funding from the state. and still a lot of uncertainty there, but the money is in fact flowing. It's a regularly scheduled meeting. It wasn't unique to that topic. Ben Franklin Council of Governments pre-audit discussion meeting and interview for upcoming performance audit. Also some discussion on policy with regard to how we're going to dispose of surplus properties in the future. We have one on A Street that is currently in the process of being sold. It was something we recovered from a debtor who was unable to pay their loan back to the community that provided the business funds in the first place. Had a couple of interesting calls from constituents on land use and development issues, following up with the city. Sort of the usual give and take between a developer and the city when the city would like a street extended or a cul-de-sac added or some feature that the developer doesn't feel that they need to do. And of course, we normally stay out of these when they're in the city, but sometimes they're in donut holes, as was the case with this one. So Ben Franklin Health District, if you heard yesterday, this morning, stats on new COVID cases are way up. What wasn't reported from the health district, and I'll be following up on this morning, excuse me, is the number of hospitalizations associated. And for anyone who hasn't heard, our ICU beds are largely subscribed, and people who are coming in for things other than COVID aren't necessarily going to be able to find an emergency room bed in our local hospitals at this rate. And WASAC follow-up. Yesterday, the weekly update meeting focused primarily on fires throughout the state and help that the state is trying to provide for us. So obviously each of those subjects has a lot more detail, but that's just a quick overview of what we've been talking about this week.
Commissioner Mullen.
So I met with the cattlemen's group, and discussion there is on the brand department. It's going to be operating in the red by 2023 if they don't make some significant changes to our brand department. Also met one-on-one with Jason Zachariah from the Benton Franklin Health Board and had discussions on the current situation here in Franklin County. Also had, I was contacted by other electeds outside of Franklin County voicing their concerns on redistricting. I think we still should move forward and seek counsel from Joel Art. Also attended the sheriff's first night out. It was very educational. We got a lot of new tools out there as far as deciphering what is drugs and what is, other substances. Pretty neat to see those items. And it's a well-attended event, and I think it was very educational for kids to get out and see everything that we have, and for the local community. With the shortage of our workforce, I was just going to make something that maybe people haven't thought about, but you can go to the LNI and get a permit to employ 15-year-olds, and there are a lot of regulations that go with that and certain hours and restrictions. But with the lack of workforce for minimum wage paying jobs, I think that businesses are going to have to start looking at every avenue they can, and that can be handled by going to LNI and adding that permit to your license. That's about it.
Thank you. We had the operation and maintenance for Ben Franklin Transit meeting last week, and not very much to go over there, just informative, but I've had calls from, that was the only meeting I had last week besides commissioner meeting, but I've had numerous calls from constituents about zoning areas. The one this morning was in that area above Booker Auction. They're wanting to put a commercial winery in there, and so I knew nothing about it. I told her then they're going to have to rezone the property for that. Also, Mirror Ministries down there, there's also people already concerned about that. I haven't heard about that. They're calling me about it. That's going to take place down there by the highway, and the neighbors don't want it. It's a needed commodity, and I think it needs to be put over there in the old Kennewick General. That's would be ideal for abuse, drug abuse, mental problems. Those facilities are there. We've done that work study on it, and I think we're still waiting to see about what could be in there for problems. But I think we could have one area facility where doctors don't have to travel to different areas, physicians don't have to. It's all right there and in different buildings, so we don't mingle these girls that are being held against their will, drug addiction, you name it, mental health. It all could be right there, and it could be a one-stop center for our physicians, for our doctors, for counselors, for all of it. It'd make it easy. You don't have to travel over the Tri-Cities. And I think this is where we need to be looking for that. Also, a lot of phone calls today on this mandated vaccination. And I've been on the phone this morning to other commissioners from other counties, and we're formulating a letter that we're going to put out there that this is your individual right, your liberty. This is free will. Was given to us by our Creator, not no government, not no governor. And for him to mandate that you have to take something is against our Constitution. So we're going to stand against this, and we're going to put a fight up against it. I've also encouraged, because commissioners have got a hold of WASAC, they're going to go meet with them on that. They're going to put out a letter also. The police force in Seattle has already put out that their union's going to fight this. This is wrong. This can't happen. It's free will. If you choose to take the vaccination, it's your choice. If you don't, it's your choice. With that, that's all I got to report, and I think we'll start on the first item on the agenda is Darrell Banks and the agreement 2163-23904 between Juvenile Justice and DCYF. Darrell.
Good morning.
Good morning.
I believe we're referring to the juvenile detention.
Yes. Yeah, I didn't say the JDAI.
That was originally on the consent agenda, and I believe there's some questions around that. Do you want me to give you some background on it first?
Yeah, give us some background, and then the questions will come after that.
So, the juvenile court has been involved with this, initiative since 2007. So, for the last 14 years, I guess. And what it really is about, it's a national and juvenile justice initiative, and it looks at like 8 different areas of the court. And so one of those might be collaborative meetings with the community. Okay. Another one would be alternatives to secure confinement for kids that can be safely served outside of detention. Another one is making sure your court processes are running smoothly and not, on the back end, keeping kids in detention longer than they need to be because their court process is inefficient. So, and then another part of that is data. So being able to pull data to look at all these different points. Another overarching point is looking at racial and ethnic disparities and make sure you're not causing more harm, reviewing your policies, procedures, practices, those sorts of things. So we've been doing that since 2007. It's not a lot of money. It's like $25,000 a year and $50,000, for a 2-year period. And we don't make a big fuss over the grant because there's not a lot of money there, and it just really has been ingrained into kind of how we approach things anyway. Okay. So lately, through that grant, and I understand this is what the potential issue is that we have the opportunity through that grant. It's not to attend some training on racial equity, inclusion, DEI training, okay, diversity, equity, and inclusion. So, and that comes to us at, it's developed through JDI or through the Partnership Council. So to back up a little bit, when we first became involved with JDI, it was through the Annie E. Casey Foundation, which is a philanthropic organization. And so that was a grant through them. Then eventually there was some federal dollars attached. And then eventually the legislature in, I think, 2004 or something like that appropriated money to continue this. And so there's 8 other counties involved in this. So not all counties do it, 8 of them do. And so through that grant, the Partnership Council through JDI and with the JDI courts involved, developed this online training that is basically free to all of us. And it's 9 hours over 3 months, so 3 hours a month. So it's, to me, it's a good opportunity for a lot of different reasons.
Questions, commissioners?
I don't have any questions.
Daryl, have you taken the training?
I did. I attended the first session of it.
How often does that run? Is it new this year or is it gone in past years?
No, this was brand new situation.
Okay. What did you think of it?
The first session I thought was pretty general, actually. It's just my perspective on this whole training is really, backing up a little bit. Our job at the juvenile court is to connect and build relationships with people. And we do that through listening to them. We do that through looking at their perspective on things or what their background has been or where they might be coming from. We also do that through being thoughtful about questioning where we come from and how we lay our own stuff on top of that, right? So to be able to do that, I think we need to be thoughtful and informed about where other people are coming from. Mm-hmm. And, over 50% of the kids that come and families that come to my juvenile court or our juvenile court are kids of color. So need to be thoughtful about that. And that's really where I'm coming from with this.
So there's no misunderstanding about my line of questioning. I think the intent of the program is outstanding. I think the program itself is pretty good. As you've already said, it's not much money. And I think the intent of the training is outstanding as well. Completely on board there. We're serving the public at large. We need to be looking at the statistics for the people that we serve and make sure that there aren't disparities there on non-merit basis. I'm good with all that. In fact, I would tolerate nothing less. But I'm also well acquainted with the state of Washington and the state legislature and the products that they produce. And sometimes their view of the world isn't quite as neutral as I believe mine is, although we all have our own built-in biases.
Right.
Just a quick aside, I grew up in an active duty military family and did a career on active duty myself and enjoyed the fact, among other things, that while certainly not perfect, our military forces are some of the more integrated in our society. And it was a great place to work and serve. So I come from that perspective to start with. Understand this training is voluntary. Nobody's required to take it, right?
No.
That's not right.
I've asked all of our staff to take it.
Okay. The contract says that we need to make it available. So you're adding a local policy that staff is required to take it?
Yes.
Okay. And that's your decision that you're making? Not, you haven't run this by Benton County or any other office. You've just made that decision within your office that.
I typically don't with training. If I do run it by anybody, it'd be with with judges.
Right. Okay. Well, since you've opened that door, let's go there, because that's exactly where I was going.
Okay.
In the contract, in Exhibit A, 1A3B, our obligation is to make this training available to our employees, right?
Mhm.
Okay. And if you mandate it to employees when it's not an obligation of the contract, and that's a decision that you're making, that has the potential, I think, given the nature of the training, to raise concerns from bargaining units and others. I've heard from them, and to be clear, not anyone closely associated with me, and you know exactly what I mean. So I'm just getting clarity on the fact that the contract doesn't require, but you are requiring it for all your employees.
Right.
So if an employee declines to do it, what is the recourse?
I would review it and take it on an individual basis. So
Okay,
just like I would anything else.
right. So you've seen 1/3 of the training.
I have.
Is the other 2/3 available to you? I mean,
Yeah,
presumably it's
I'm
been
already
created.
signed up for that. And then there'll be an additional round of trainings in the future. So in the spring.
So you're mandating training you haven't seen.
I've reviewed the training. I've talked to the trainer and I've talked to the people that put it together. And I believe it's a good opportunity for our staff. So I kind of approach it this way. So over the last 34 years, I've gone to a lot of different trainings. Some I didn't want to, some I thought wouldn't be very good. But I showed up, I was professional, I tried to keep an open mind, and sometimes I learned something, sometimes I didn't. And so that's all I'm asking my staff to do.
So like you, over 40 plus years in the military, you don't have a lot of options for what training you sit in on.
Right.
And I've done exactly the same that you have. The point that I'm drilling down on is that you're making a decision to require this training, yet you've not seen the full course. Is the other 2 blocks, are they available to you now? I realize the schedule, it's a third, a third, and a third, but
Right.
presumably the training already exists. It's sitting in somebody's computer. Have you looked at the entirety of the course before mandating that your employees take it?
I looked at what I believe you already have, which is do you not have that? The description and the learning objectives?
Well, what I have is the contract language. I don't have
I'm
the,
sorry. I have a copy of it if you'd like it.
sure.
Copy for everyone.
Yeah.
Thank you.
Okay, well, rather than take time to read it in detail now, quick review, it looks like it's fairly routine communication, identifying and addressing any individual bias you have, regardless of who you are coming to the training, because obviously this training is not for any one group, it's for all the employees. Your statement earlier, just to be clear, when training is offered by the state and it's optional or it's in a contract, you don't generally discuss that with the judges or anyone else. That's just a decision that you make. I think that's what you said
Sometimes.
earlier.
No, I said I talked to the judges basically if the judges said, Daryl, don't do this training, I wouldn't do this training.
Okay.
Sometimes I review that with them, sometimes I do not.
Have the judges asked you to do this training or not do this training?
They have not asked me not to do it, but they're here, so they could answer. my
Right,
question.
sure. But you said earlier you discussed it with them? So
I
I'm,
have discussed it with them.
so rather than spend time talking with them, I can just assume that you're all in the same perspective on the training. Everybody supports it.
That's my understanding.
Okay, Well, if it's any different than that, I'm sure the judges won't hesitate to let me know.
Right.
Okay? Thank you.
So Daryl, oh,
Oh,
go ahead,
no,
Rob.
I
Oh, I'm
was just
sorry.
gonna
I thought
Go
you
ahead.
didn't.
No, I'm sorry. I did earlier. There, I just want to say thank you for that, having the attitude of going there with an open mind and listening, because sometimes when you think something might not be that important, it turns out this could be very educational. And I just want to say I appreciate your attitude in the training.
Thank you.
Thank you.
You said there's 8 other counties, or we're one of 8. Who are the other counties that are?
I knew you were going to ask me that. So, of course, some west side counties, right?
There's only 8 out of the whole 39 that are participating in this?
Yeah,
Is Benton one of them?
Benton, Franklin. So
Yeah. We're counted as
we're
one.
counted as one.
Okay.
Snohomish, Pierce, King, Whatcom, Adams, Clark, Mason, Pierce. Did I say
Okay.
that? Yeah, so that's what.
So as I read through these and what you're trying to learn, like Commissioner Peck said, in the military, it's a team. And when I played in the NFL, we were brothers. We played as one unit. And if you don't, you're not successful. We had a great leader in Joe Gibbs, but we brought everybody together and we focused on the task at hand, and we were one force, one direction. And that's why we were able to get to so many Super Bowls. And so I can see what's taken place here. And to me, it looks a little bit like critical race theory. So do you have that comparison too?
I did not, I mean, I know a little bit about critical race theory. If you have a good knowledge of it, enlighten me, but I did not compare it. I did not see
Okay.
it drive together, no. In fact, I asked that question of the presenter, and he said, this is not that.
Okay. Well, I appreciate the fact that you're going to go and listen with an open mind.
Right.
But I'm telling you right now, I feel like this whole critical race theory is doing nothing but dividing our country.
Yeah, and like I said, I don't believe that's what this is.
I hope not, but
Yeah, I do too. So, but I don't,
but I would
that's not the
say
impression I got.
go there with an open mind. And
Right.
but after reading through it, I see a lot of it's on race. It's all racial, and so that concerns me. But go with an open mind, and I guess we'll get out of it. It's a grant, right? This is all grant funds.
Mhm.
And Benton County's already on board?
Well, I wouldn't know that they're on board. They have to sign the grant. But
They haven't signed it yet?
no.
Okay,
So it always goes to Franklin County first and
okay.
then to you folks. So,
All right, that's all I got to say. Thank you.
well, while I have your attention, first of all, I really wanted to, we're right in the process of our gearing up for our education employment training program. And one of the things that Benton County has done is renew their minor work permit. And so I was really happy to hear that, because we have a whole program around employment, training and work experience and that sort of thing. So it might be a situation we can explore with some appropriate kids if there are certain jobs within the county that they could do. So, and then the other thing is, we've talked about this before, but our water cooling tower at the court is from 1977. Okay. And it has been waiting to die, and it's probably in hospice right now. Okay. And if we make it through this next week, we'll be lucky. But the problem is, it's our last quote, and I think 2019 was like $150,000, and it takes 4 to 6 weeks or 4 to 6 months to build. So that's a problem. Sheila Berry, our financial manager, has just accepted a new position with Benton County. So we'll be replacing her. And it was quite a bit more money, so you can't really blame her. But I have 4 openings in juvenile detention right now, and I can't find appropriate people to fill in because the wages are so low. So I'm bleeding people right now, good people. And then on top of that, the health district may lose their insurance to provide medical in our detention center. So, and I don't have a good solution for that yet. So it's been a great week. Anyway, thank you.
Thank you, Daryl.
Thank you.
Hey, Daryl, before you leave, a couple of other questions I wanted to follow up on. I just didn't want to interrupt you when you changed topics. Can you send me the links for this training? I presume anybody that wants to.
You can, yeah, I think this series is full, but the one coming up in the spring, there's still room in. So I can send you that.
This is online training, right?
It's online training, yeah. They have a certain cap on the number of people for each one.
Okay.
But yeah, it would
Perhaps
be
you
open.
could send me a note and we could watch the next module in your office.
Sure.
Okay.
All right. I enjoy that.
Just want to close out with this thought. The language and the intent of this, which I've now had a chance to read, doesn't concern me in the least. What concerns me is the way that I have observed over 13 years and sitting in this seat, how well-intended actions at the state level end up causing conflict and controversy by virtue of their execution, how they're written, how they're presented, and not having had the benefit of seeing it, it makes it challenging. If the course content or the course itself was not required, mandated by you, and people had the option, I'd be fully on board. I'm reluctant to have you telling our employees in the county that they need to take this training that you haven't seen yourself. That concerns me as a leader. I think that fails the litmus test of not asking your folks to do something without knowing what it is you're asking them to do. It's not that the training itself or the context or the subject matter, none of that bothers me in the least. I think it's very good, in fact, if it's executed properly. But again, I've seen our legislature execute things, I don't know, maybe a thing called the Blake decision, that had really well-intended consequences, but it's created one heck of a mess. And not making a direct parallel between the two, other than just because it comes from the state doesn't mean it's necessarily well executed or productive. In fact, in my mind, I've come to the point where I think it automatically calls it into question. So looking forward to that invite. And,
well, I share that opinion, Commissioner. And there's
but
been various.
But you've taken the position that even though it's not a requirement of the contract, you're going to mandate that your employees take it, and you haven't seen it. That's what concerns me.
Okay, well, I understand that.
Okay, good.
Now, Daryl, did you mandate that they have to watch this? Because you said earlier that you asked them to watch it.
That's correct.
Well,
That's the change from the
They
last
asked if it's
discussion.
mandatory, and I said, yes, it's mandatory.
Okay.
Okay. So it's relevant to our work, I believe.
Okay.
So.
Daryl, just one other quick question. Do you think that your people will be unable to successfully execute their mission without this training?
I think it enhances their ability to do that. And I think another thing,
But you haven't seen the material. That's an odd juxtaposition. You've made the decision and evaluation that this is going to help them do their job, yet you haven't seen the material. That's what I find odd.
okay.
Thanks.
All right, with that, is there a motion?
Mr. Chairman, I'm inclined to wait and see what Benton County does on this issue. I want to be very clear so that no one misunderstands. The intent of what I read here is outstanding. I think our society would benefit from it if it was done in a truly neutral fashion. And we all have our own inherent biases. That's the nature of being human. I just have, at this point in my career, almost zero trust in the state of Washington to put forward training that is in fact neutral in that regard. And I think it fails the leadership test for one of our senior managers to require his people to take training and look at and receive content that he himself has not seen. He might argue that it's not available to him, but I don't buy that argument, and I think he should have reviewed this course material before making a requirement that is not a requirement of the contractor receiving the funds. So for me, it's really more about a leadership management issue. I think Mr. Banks should have reviewed this material and then been able to come in here and say, I've looked at all 9 hours. I think it's good. I think it's productive. And I'm going to recommend that all of our staff do it. On that basis, I'd probably support it. But the fact that he hasn't done that, I think it'd be interesting to wait and see what Benton County has to say.
I concur with Commissioner Peck. I think that we should know exactly what's in the course and have observed it before we make something mandatory for the.
It's consensus. We'll wait for Benton County's decision. We'll see what they do. Absolutely.
Excuse me, I've listened to your comments and I appreciate your comments and I think they have some validity. So I'm not disputing that, but I just want to, but I'd like to, oh, wait. Okay, is that better?
Yes.
Okay, thank you. But I want to make it clear that Daryl did discuss this with the judges, me in particular, and I with the other judges. We have not personally reviewed all the information and sat through the training as of yet. I reviewed what you've reviewed today. And from that perspective, it seemed to me that something that would be valuable to our employees to go through this. And I supported Daryl in his decision, and I still do.
And Judge, I'm with you right up to that point.
Okay, all right. And I understand your concern regarding supporting something that we haven't had all the details and actually sat through the entire training, making that mandatory. But so Daryl did discuss this with me. I want to make sure that you understand that this is something that I, as a judge, discussed with him and discussed with the other judges. I kind of feel like I'm throwing Daryl under the bus here a little bit, and I don't want that to be the case because I know he has certainly discussed that with us. The Supreme Court, our Supreme Court, regardless of what you think of some of their decision making, we are bound by the decisions that they make and the directions that they give us. And they have directed us to take active steps to address our cultural competency and improve our abilities to deal with what's becoming an increasingly diverse population that we're dealing with. And reviewing this with Daryl, and again, I reviewed just what you reviewed. It seemed to make sense to me, and I discussed with the other judges, and as far as I'm aware, they are all in agreement. So again, I think you alluded to this, Commissioner Peck, that you didn't need to hear from all of us because you were assuming that the judges were all on board, and that's my understanding. But I did want to at least stand up and reiterate that the judges do think this is something that is valuable and that helps us further our mission at the juvenile court and trying to provide a service to try to minimize impacts on our community from criminal and other behaviors that impact the community and trying to deal with them in a way that's going to hopefully help them and help our community as a whole. So again, I wanted just to step up and say that. So thank you for listening to me and indulging me. I appreciate that.
Thank
And Judge, if I might just briefly respond to that. You and I have known each other for a while, not closely, but through our work. And I want to be clear, I've got the utmost respect for the court and for our judges and for your point of view. And I'll just say with due respect, I would not mandate any training that had the potential to lead to a discussion like we're having now, right? I would be very reluctant to mandate that for any of our county employees without having first looked at it fairly closely myself. If it were a driver safety course where we're not promoting a course where we're going to have how do I say it? I'm wanting to be careful that my words aren't misinterpreted. The nature of any training, whether it's racially related or completely in an entirely different context where there's no discussion, there's no debate. For example, a discussion about whether or not we ought to have substance abuse disorder training or mental health services for our people. Those kinds of training programs I've got no issue with, because when the state sends those out, they send them out and they say, we need mental health training. We think you should support it and we think you should fund it, but they don't mandate the training. In this case, they've treated it exactly the same. They said, we think that there's value in these training courses. We're following the lead of the state Supreme Court, and we think it's useful for your people to have this training. We don't mandate the training in the first case, but we do in this case. And it's a disparate treatment of the mandatory nature of the training that is really my sole issue. And if Daryl had come in and said, I've looked at all this course content and I don't see any issue with it, then we'd be having a different conversation. This would have passed on the consent agenda on July 20th. So sorry for the rambling response, but I want to just be very clear that my issue is that when we change our policy and our philosophy about the way we handle a decision, and we happen to do it on an issue where some people, personally, I think improperly, but some people have a question or an issue simply because it's a race-based question. I think the change in the policy and the practice itself feeds that kind of inappropriate disparity or perception. Am I making myself clear?
I think I understand what you're saying. I'm not sure that I agree that we are changing our policy and procedure, how we handle trainings at the juvenile court.
Yeah. I don't recall us ever having a contract where the state said, we'll give you this money, we'd like you to do this training, it's optional, and then we made it mandatory. If that's happened before, then I didn't catch it. And maybe Daryl, if that's happened before, you can give me a call later and explain to me. It's unfortunate that the nature of the training is sensitive for some people. As I've already said, I think it's probably good content, and if I knew based on this and I could trust the purveyors of the product, the state, I'm quite sure I'd have no problem. But this last legislative session and seeing the things that came out and the efforts, albeit let's give them the benefit of the doubt, well intended, had some catastrophic effects for counties that frankly I don't think are felt yet. And as I said before, I'm not drawing a direct parallel to say that this training is going to have some catastrophic effect for us. It's not. But from a practical matter, as a leader and as a senior manager in our organization, I don't want anybody telling our people, you have to do this training if they haven't looked at it themselves first. So if Daryl wants to go look at it, come back, say I've been through it and it looks great and I don't have any concerns, I'll take a different position.
Thank you. Appreciate it.
Yeah, we haven't said no, but we want more clarity from our neighbor Benton County and have them ask some questions too.
Oh, I certainly appreciate that.
Because if you're watching something the same time your employees are and you find something that you don't agree with, it kind of makes the leadership look bad because they're not prepared to possibly answer those questions, or they get caught with, I don't agree with this because I'm seeing it the first time you are as well. I just think as a leadership, we should, thoroughly go through the information first before we mandate it onto someone else.
Thank you.
All right. Thank you.
Thank you.
Next on the agenda is the Bi-County temporary staffing positions for the Blake caseload, case manager, and court commissioner. Tiffany.
Hi.
Good morning.
Commissioners, good morning. And Commissioner Mullen, COVID means that I don't think I've seen you since you assumed the position, so congratulations.
Oh, thank you.
To start off, I wanted to explain from the bench's standpoint what we're dealing with and the additional workload that Blake is going to put on all of us. As you know, the Blake decision came out in February of this year. The legislature responded with legislation in March.
Forgive me for this. I just can't help myself. Judge, Are you suggesting that our state legislature could actually produce a well-intended product that has unintended negative consequences for counties?
Commissioner,
Rhetorical.
Commissioner, I appreciate that you phrased it as a rhetorical question because the bench, as a neutral arbiter,
I understand.
hopes to avoid answering such questions.
Thank you.
Right, yeah. No, it's just in light of our most recent discussion and my inherent lack of trust of products coming out of our legislature these days. Sorry, my apologies.
We are in your house, sir. So with that, the legislature, as part of what has been called the Blake fix, has set up some procedures that will allow us to enter amended judgment and sentences remotely. Now, as you all may know, what Blake means is that unlawful possession of controlled substance convictions that existed prior to March are void because they've been deemed to be unconstitutional and void. What that does is it creates a void judgment and sentence for every judgment and sentence that has an affected UPCS conviction. Now, that starts with the very simple circumstance where you have an individual who's been convicted of a single count of unlawful possession of a controlled substance. You simply enter an order, you dismiss the case, and you wipe the case from the record. Now, it's not all that simple because you then have requirements for refunding LFOs, and Mr. Killian can tell you some of the challenges that come in there. But there's a second class of cases that we're going to see in the court, and those are ones where we're simply removing a single count from a criminal history or an active conviction, and we're creating an amended judgment and sentence. And you need to do that because you need to have good records of what the conviction actually is. Now, where both sides, the prosecution and the defense, can agree that this is in everybody's mutual interest, there's an agreed sentence. What you can do is you can even do this from the Department of Corrections. We can use the video conferencing links that we have to have the defendant appear, have the attorneys in the courtroom, and we can get them done. In Benton County, what we're doing is we're setting them on the end of the ex parte docket in 10-minute blocks and trying to get those out. Now, what we're doing, and I hope the commissioners will appreciate this, is there isn't a formal procedure with the Department of Corrections. They will create one someday. We are, however, attempting to set up our own procedure and get them done before the flood of other counties begin inundating the department. We want to get them done as quickly as possible. And it's easy to do if it's simple and everybody is agreed. The problem multiplies where you have individuals who may have been previously convicted of very serious offenses, up into including murders, where they have a UPCS conviction as part of their criminal history, either as a count of conviction for their current judgment and sentence or as part of their criminal history. So again, a void conviction creates a void judgment and sentence, creates a requirement to resentence. This, of course, implicates victims' rights and a full resentencing here. Now, again, there are possibilities for people to waive these things. There are certain circumstances where people will have accrued additional criminal history, and it's not in their best interest. And so, but we leave that to the litigators.
Unauthorized possession of a controlled substance?
Correct.
Okay.
Yes.
I was listening, but I was also trying to figure out what in the heck is UPCS? But I got it.
Right. But, and I apologize.
No, it's okay.
It was, I always tend to state the crime first and then go to the abbreviation.
Yeah, it's okay.
Yeah,
I knew the subject. I
all
just wanted to kind of make sure everybody listening who might not know what UPCS is. Anyway.
Fair enough. And so because these things go back, as we're told, into the early 70s, as far as the affected convictions. And again, many people with very early convictions will have served their sentence and will have no interest in the process. But there are lots of people who are confined in the department who would like that option because it'll lower, in some instances, their guideline range. And so it's these cases, not only the LFO end, which burdens the clerk, but also the resentencing end, which burdens the court and both the PD and the PA. Now, again, in all of this complication, and I should indicate here that we all have various roles on the bench. And I'm a little fuzzy on the process by which this happened, am the Blake representative of our bench. So I'll be handling both the planning of how we're going to deal with these and then many of the hearings. But in that role, we've been working with AOC, and the state has here, and I know that an unfunded mandate is this board's least favorite thing. The state has budgeted money, and so we will be able to be reimbursed for our time and effort. And so what we're asking for here, both on behalf of the courts and on behalf of the clerk's office, are positions that will be for this county's portion reimbursed by the state. And we got numbers today, and our court administrator can tell you about those, where the funding allocated appears to be sufficient to fund what we're asking for. And again, these are limited duration because these won't last forever. They will be a period of years where we anticipate that we'll be having to work our way through them. But what we're looking for is a part-time court commissioner position, and then also the staffing to support it. Now, I want to explain a little further why it is we're looking at a court commissioner as opposed to some other alternative. First of all, judges come in whole, not in half. And so, again, trying to be careful about public funds, this is what we initially believe will serve our needs. But also, while the legislature has allowed us to do these things remotely and has allowed for commissioners to do some of the resentencings under Blake, there is a particular difficulty with just simply assigning a commissioner to it. And that is, as you may know, a court commissioner is subject to a right of revision, where a party who doesn't like the decision can ask a judge to review it. And it just duplicates work if we give cases that are likely to be subject to disagreement to a commissioner. We just end up doing the work anyway. And so the idea, and we want to be transparent about this, is that the commissioner position will allow us to free up some judge time for these hearings by taking on some other obligations that a commissioner can do without having it be repeated. So what we're attempting to do is not outsmart ourselves by how we be allocating these resources. And again, as you may imagine, there are various different ways to calculate what you think you're going to see as far as cases and how they're going to progress through our system. And what we have learned during COVID is that if you don't have a plan, what you have is chaos. And so we also need a staff person to make sure that the procedures that we've agreed to with the department are being followed in the way that the cases are set up. And in this sense, it's actually a fairly delicate balance with the department. The department has asked us to give them a certain amount of notice and to give them certitude as to where they're going to be phoning in. They don't want to be chasing us for hearings. And so we've done that in Benton County, and we anticipate doing that in Franklin County as well. But if we don't have somebody controlling the flow of these things and people are noting them up willy-nilly on the dockets, we run the risk of alienating the department and not being able to get these cases resolved before what we believe will be a very large push by 38 other counties.
So, Judge, I'm trying to refresh my memory by scanning through the agenda summary report here, the read-ahead material. Maybe save me a little time and trouble. What's the window for these positions, and what's the degree of certainty that the funding will materialize? And is this a well that when it runs dry, we're all done?
The numbers are in front of our court administrator, and it's a question for her. The answers to all of those are yes, but she is the subject matter expert.
Okay, well, if I hadn't forgotten to charge my iPad, I wouldn't be trying to read this little tiny print on here. So maybe you can help me out.
We actually just got,
Can you bring the mic over?
Oh, certainly.
I'm going to hand this to you guys real quick. I just received this yesterday from the AOC. They have actually allocated what each county is going to get under this funding. It's on page 3. I've highlighted it for you.
Thank you.
I think there's one comment that, because I know the Board of Commissioners pays attention to its fellow board. You will hear in Benton County some dissatisfaction with the allocation. The allocation is based on the current population of individuals in the department, which is believed by some, including me,
Which department?
the Department of Corrections,
Okay.
to be a troublesome metric for what each county is likely to see. We believe that's low for us.
So it's corrections staffing relative inmate population or just staffing relative county population? What's the metric?
Well, they're using the number of individuals currently confined in the department that they believe possess that qualifying conviction.
Okay.
And then they're using a metric tied to the county that we don't believe accurately reflects what we're going to see. Mr. Killian can tell you a little bit more about that, about how the clerks don't believe it's accurate, but we still believe we have the funds.
Right, they asked us, the county clerks throughout the state, to do a report to the AOC for a 10-year look back, but these cases go well back to the 70s. And so the AOC's methodology and what DOC is using, we don't feel is accurate, and neither does WASAC or WAPA.
So the statute goes back 20 and they're asking you to look back 10.
Correct.
And I think it's kind of obvious
For
to make a big
instance,
difference what that first 10 years looks like.
right, so for instance, we have well over 1,551 Blake cases in Franklin County, but they're saying there's only 311 that need to be resentenced. So those numbers don't even match up at all.
Is there any reason to think that there's going to be an opportunity for additional funding or a redress of these?
Well, those things are
Numbers.
being asked. Again, there was a letter that was sent to the state courts, and then they responded yesterday with this information, which again is skewed in my opinion.
Do you think that our accepting this money would any way eclipse or foreclose our ability to press the issue of numbers?
I don't.
Okay. That would really be my only concern. I mean, if they're going to offer the money, let's take it, so long as it doesn't compromise our ability to still press the other issue.
Right. And I think if we don't get this moving quickly, then we're going to be behind other counties, and then that money is going to dry up a lot quicker.
Well, that's the well I was referring to. And if we aren't able to get answers on the first 10 years of the 20-year window before the well dries up, and that's my fear, is that the state is going to want to deal with this. And we'll get to your question when we get there, and then we run out of funds.
Right.
So
This allocation is $44,500,000, but in the read ahead, it was allocated $72,500,000, but the first year is $44,500,
The 72,000 includes,
72 million.
72 million, sorry, includes some for the Blake court hearings and then some for the LFO refunds.
Right.
So they've separated it. So the portion for Blake, addressing Blake cases, is the 44,500,000. And then they've allocated that amongst the 39 counties based on the numbers in the DOCs. And so what, for addressing the Blake court hearings to resentence, they've allocated $732,300 to Franklin,
Mhm.
$1,823,000 to Benton.
Okay.
And our goal in talking about that metric and some of the concerns that we have with it wasn't to start a fight. We didn't want you to hear about it from Benton County in the first instance and then wonder why we hadn't brought it up to you.
I think people would be surprised at how much the two counties communicate these days.
I don't doubt it, but
So your concern is well-founded.
we believe that candor here is important.
It is. So I'm noticing in the copies of this document that the Superior Court Judges Association, the District Municipal Court Judges Association, the Association of Washington Superior Court Administrators, on and on, are all copied on this document. Did any of those organizations have a voice, do you know, when this was being formulated? I know it's a pretty open question, but.
There was input from all of the organizations.
Okay,
The ultimate decision may not be to the liking of all organizations.
understood. Thanks.
Is that fairly stated?
I totally agree.
All right.
Very, very adroit and neutral.
So we strive for.
So do you believe the 23,500,000 is adequate for the legal financial obligations?
That is a question for the clerk who has the data.
Well, for statewide, that's
That's statewide, yeah. I didn't,
Who's on the hook if it comes up short? Is it counties or the state?
The state would be on the hooks. I mean, the counties, we don't have the money, so.
Well, not having the money has never kept us from being on the hook.
There's no money.
There's this thing called insurance.
There's no money, no refunds. And that will be back on the state.
Okay.
But again, that's why we want to get in front of it, so to speak, the cards, to get this resolved for Franklin and Benton County before the other counties.
So you're asking to spend the state's money to get help to do work you are obligated to do. It
Yes.
seems pretty simple to me. I just
Yep.
appreciate the discussion about the mechanics of a decision today and how it may or may not jeopardize our ability to get our hands back into the pot later on. So appreciate the discussion, but
so how many of these detainees could be back 20 years on a possession? Just straight possession, because if they were involved in a murder, I mean, that's going to take precedence over the possession.
Right.
How far back do you think we're going for people that are still detained on just possession alone?
It's been I believe it's been the intent of the prosecutor's office to prioritize those and get those dealt with. I don't want to speak for the prosecuting attorney's office in Benton County, but it was their goal to identify and resolve by now those individuals who would be entitled to release under a resentencing calculation. I don't know that based on the data, it's fair to hold them to completion because it has been difficult finding these things out.
And what about possession with the intent to distribute?
An entirely different situation because the mens rea element, the intent, has by both statutory language and by case law been included for a period of time. So it's not affected by Blake. And I can tell you that with some assurance because in addition to my other Blake duties, I'm also the representative for the jury instruction work group and sent off the most recent version of them yesterday to the committee.
So just for clarification, they're saying that you have 311 people that are detained, and yet you think the number's closer to 1,500?
Well, there's 1,551 total Blake cases in Franklin County, and many of those have already been dismissed because that's just the single charge.
Okay,
I mean, we've probably done well over 300 of those in Franklin County. The state is just saying that there's only 311 in DOC that need to be seen by the judges in Franklin County, but we believe that number is high.
Yes, so
To be resentenced.
to be resentenced. And so they're looking at the individuals who are currently detained who are affected by Blake, but there are many individuals who are not currently detained who have judgment and sentences that are affected by Blake. They're void on their face. They have a right to be resentenced.
right.
And so by looking at those folks who are currently held in custody, you're not getting an accurate picture of the total universe of individuals who have a right to be resentenced.
All right, thank you.
A little clarity for the uninformed here. We're talking about resentencing, but I'm not hearing anyone talking about convictions being overturned or expunged records or felony status rescinded. Could you speak to that a little bit? Or maybe Mr. Sant would?
Only within my lane, yes.
Yeah, Mr. Sant might.
I can tell you that, that we sign orders that essentially dismiss and vacate a conviction if it's simply an unlawful possession conviction itself. And the consequences are that those things are as if they never existed. The constitutional infirmity means that they are void, and our order by dismissing them voids them.
And so that action you just described, which was very clear and helpful, is that fit in the bucket of what you've been referring to as resentencing?
They are Blake affected cases, but I don't think that I don't believe they're counted by the department.
Okay, and that's where I was
they're
going.
Simple dismissals.
Okay, and that's where I was going, because if those simple dismissals were part of the number, then it would imply the universe of cases, a large part of which are pretty simple. But apparently they're not included, so that's just useful.
Right, yes. Those things, we're not troubling you for an order that we would simply sign on the ex parte document.
Right. I was just looking at the universe of cases you have to deal with and getting a sense of whether or not those simple ones are in that bucket. And again, they're not. The ones you have to deal with are actually going to take some staff time and some court time.
Correct.
Okay.
So we're talking about current cases, people that are still being detained. What about people that have served their time and they're released? Is there LFO for them?
In many instances, yes.
So this 23 million isn't even going to make a.
The belief that that's insufficient is shared widely.
Yeah, it's clear. What's unclear to me is who they're going to send the bill to for the remainder. And I think I know.
We leave that to the partisan office holders.
Right, yeah.
Okay, is there any other questions?
I have no further questions.
Move for approval of resolution 2021-169 is presented.
Second it.
Been a motion and a second for approval of resolution 2021-169. Discussion?
Thanks for giving us so much of your time. When we get judges in here, we like to chat.
No, I added clarity rather than confusion.
Thank you for your time.
Yes, good presentation. There's been a motion and a second. All in favor, say aye.
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 Aye. Okay, right down to temporary staffing positions for Blake caseload, LPA 2 deputy clerk, presented by Tiffany.
That was kind of all grouped up.
Basically, it's all encompassing. For the court commissioner and the second is for the clerks.
Right. So move for approval of resolution 2021-170 is presented.
Second that.
There's been a motion for approval of resolution 2021-170. Discussion? Hearing none, all in favor, say aye.
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 Aye. Thank you. Thank you for your time and good luck.
Thank you. If the board has additional questions, I am your point of contact in our
Okay.
office.
With that, we're down to public comment. Is there anybody on the line, Keith?
No, sir.
Nobody on the line? Anybody in the room for public comment?
George Dockstuder, 4951 South Landing Road. I've noticed that you guys have been meeting in executive session, and I'm assuming it's regarding the lawsuit on the redistricting. I'd like to know where we're at as far as our so-called public input that our redistricting committees. Where are we at on that, or have they done anything?
I know this is public comment, Keith, but I think it'd be good now to update the public on where we're at with our newly formed committee.
Yes, certainly. Thank you, George. I appreciate the question.
And yeah, before we get rolling, is Mr. Sant still out in the hall?
without talking to the judges.
Yeah, I just think because we're discussing an issue of pending litigation, if not an obligation, there's at least an ethical responsibility to have them in the room. It's for the protection of the public as much as anybody, so we don't get into stuff that compromises litigation.
Nowhere to be found?
All right, well, I guess is what it is.
I still think I can respond adequately for what's available in the public. It's not a secret that a group out of Los Angeles has filed litigation for us to review our current maps and district allocation. We have formed a citizens committee to review proposals. They have not yet met formally. That is a function of litigation strategy that I can't really discuss too publicly, other than we are working with some outside legal counsel on trying to address the claims that have been placed against Franklin County. Once we have a little bit of clarity regarding what census numbers would look like, that data is probably available later this month, maybe next month, where we don't have certainty as to when that's going to be available. But the task force has been convened and is ready to review any potential proposals that come forward.
Well, my concerns are that if they don't meet and don't come up with some solutions that represent the people of the county, it's going to be the courts that are going to decide what we do instead of us having any public input to it. So, and I haven't seen any notices on email blast about them meeting. And it was just something I thought maybe we ought to be getting at least a general meeting to get started.
Yeah.
So they'll know what they're facing too.
Yeah, those meetings will be open and available to the public to participate in, and we'll be able to go from there. That's kind of where we are right now.
Okay, thank you. All right.
Thanks.
Thank you. Okay, with that, we're down to any other public
I do
comment?
have one
Okay.
caller on the line now, Commissioner. Good morning, Mr. Rose.
Yes,
You have the floor for 3 minutes, please.
I don't need 3 minutes. But basically, the first comment I have is on the juvenile justice, CCYF. And the language of equity speaks of CRT. That's number one. Number two would be the fact that I wonder if the judge who spoke makes his decisions based on total exhaustion of the facts or the issues versus just perusing the curriculum, if you will, or the basically not coming to a conclusion without looking at all the facts. Facts or the issues versus just perusing the curriculum, if you will, or the
I can't hear him, Keith.
He's got his playback going on. Thank you, Mr. Rose. Was there anything additional that you had?
Two things. One, what is the authority, or where does authority come from for the state? No, I'm sorry. That's not what I want to say. The county commissioners are given authority to act and represent us.
Mhm.
Where does that authority come from? Is it a charter? Is it a constitution?
Can I ask you to turn your device down? We're getting your feedback. Thank you. The basic authority for the County Board of Commissioners comes from the Constitution and from state statute.
We're not a charter county.
Correct. We're not a charter county.
So where does the authority come from?
That's provided in the state constitution, I believe.
So are you an independent body? Or in other words, are you a sovereign body? Are we a sovereign county? Or are we an appendage of the state? I think
Yes.
Mr. Peck certainly pointed out that he has some basically some differences of opinion as far as what's coming out of our state legislature. What pushback, or what, if you will, how do we say no to what's coming down the line?
Yeah, typically that is addressed through the legislative session. Franklin County is a creation of the state, and so we are obligated to follow state law as it's been adopted by the legislature and signed into law by the governor. So a level of pushback means we convey our position to legislators who then can make those changes in Olympia.
Well, again, my question comes back to presiding authority for law enforcement. Who would be the presiding authority? The sheriff, the police, or the state police?
Well, law enforcement under the state constitution is designated to the sheriff as the leading law enforcement authority in Franklin County. His authority extends primarily to the non-incorporated areas of the city. Within the city, the Pasco Police Department or the other municipal police departments do have primary authority, but chief law enforcement authority in the county lies with the county sheriff.
The basic premise here, my whole worry, is about the decisions and all of the legislation coming down that basically makes us more unsafe. I don't know if anybody else feels that way, but letting people out of jail for misdemeanors is the broken glass theory. Unless you get rid of the graffiti and the broken windows, the next step is going to be elevated as far as crime. And so if we want to look like San Francisco, Portland, or Seattle, I guess this is the way that we go. But I would like to see the commissioners, which I've seen today, fight that with every fiber of their body, that we do not turn into a city where literally last year they're destroyed. And the way you do that is you uphold the law, and if the law is unconstitutional, then you just say no. That's where I'm coming from. Thank you very much.
Thank you. No other callers. Sure.
Callers, and we're down to the consent agenda, and on my hard copy here, we've already decided on the juvenile cost share office, so I'm going to revert back to the white copy. There's two items on the consent agenda: the revision of the payment method for vehicle allowances, and the second is a Uniform Guardianship Act agreement. Is that right? The two that we should have on there, because we pulled the one and went to, we tabled it till next week, or?
Yes, there's two items on the consent agenda today, the juvenile cost share and the Uniform Guardianship Act.
But no vehicle no revision of
Correct.
payment method?
We have some additional homework to do on that before bringing it to the board.
Okay.
Yep.
That's what I was confused about. So there's two items on the consent agenda, and I guess they're right on the blue copy.
I think we have some payroll or warrant work to do
yes,
as well.
yes, I'm sorry. We do office business first, the vouchers.
Move for approval of fund expenditures in the total amount of $474,642.82 as presented, and note that it has been reviewed and signed by two representatives of the auditor's office and the county administrator.
Second.
Made a motion and a second. All in favor, say aye.
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 Move for approval of salary clearing payroll and emergency management payroll in the total amount of $972,415.17 as presented, and note that it has been reviewed and signed by two representatives of the auditor's office.
Second.
Made a motion and a second. All in favor, say aye.
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 And now we're down to the consent agenda with two items.
Move for approval of consent as presented.
Second that.
Been a motion and a second for the two items on the consent agenda. All in favor, say aye.
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 Aye. Keith takes us down to administration office business.
Yeah, the only item I have for discussion decision this morning is the state auditor, when they perform our annual audit, requires that they do a risk assessment interview with one of the county commissioners. Historically, Commissioner Cook typically responded to that, but it does not necessarily need to be the chairman, but that may be the preference of the board. What it is a questionnaire, sit down with the audit manager and go over some high-level risk concerns that they will be looking at during the audit and asking questions of anything that you may be aware of that could provide risk to an audit. So it's a necessary function of the audit process. It's not particularly complicated or difficult. They do not only one with the county commissioner, but they do the same interview with me and other elected officials in the county as part of their audit procedures. So I'm just looking for which one of you wants to participate in that interview.
When will the date of that be?
We'll need to set that date up once, and that's what they're asking for is a date and who they'd like to meet with. So I'd leave that to the board to decide how you want me to respond to the auditor.
If the chairman has previously done it, I'd be willing to do it. If that's the consent of the board.
Anybody can do it. It's been a mix over the years, but I'm delighted to have the chair do it. I just did one with the Council of Governments.
Okay, sounds good.
I'll have that set up for you.
Okay.
Thank you. That's all I had this morning.
So we're down to public comment. Is there anybody on the phone or?
No one on the phone.
And with that, I have a request for an executive session. After talking to a constituent this morning, I'd like to call for RCW 42.30.110, paragraph 1, subparagraph I, and I would request Sean to be in the room.
I recall from memory, is that the one on potential litigation?
Yes.
Yeah, so an attorney is required. Thank you.
Yeah, so if you could bring Sean up, I got some questions.
Commissioners, I will text Sean and let him know to come back down. He's in a meeting.
Okay, thank you.
Jen, I'm going to hang up the phone and then I'll start a new comm line.
I think we could probably get away with 15, 20 minutes. It's just clarification.
Welcome.
Oh, Sean's got to come in yet.
If you are the meeting host,
Jen, are you on? Oh, okay. That's fine. It sounds like Sean is in a meeting with the sheriff and judges on another issue, but Jen Johnson is available. I'll defer to the board if that's sufficient.
Is she on her way down?
She's going to call in. I don't believe she's in the office right now.
Yeah, well, I'm not requesting the executive session, so I'll defer to Commissioner Didier since it's his
Well,
request.
if she can't answer our question, we're going to need Sean. So I'm fine with her on the
Yeah.
phone. You want me, I'll close the door?
If the
Actually,
question
I just-
requires an action out of that office, then Sean's going to be required.
Sean's been notified and he's on his way back down.
Okay.
Are you Jen?
This is Jen.
Thank you.
Yes, and Sean's on his way down.
Thank you.
Oh, good.
Okay, we have come out of executive session. We're back in regular session. Is there any other business for the good of the county? Hearing none, this meeting is adjourned.